Is it copies? All right, so you have copies attached to your originals, is what you're saying. File. You get the tested copies at the clerk's office.
Great, thank you.
All right, thank you. Runger versus Robbins. We're here in the matter of Runger, Scandinavia Rungers versus Stephen Robbins.
Good afternoon, Your Honor.
Good afternoon. File 1250185CZ. Present in the courtroom is Mr. Zesson representing the plaintiffs, Mr. Alvarez representing the defendant. Correct?
That is correct, Your Honor.
I was just worried that I didn't have your name right, but I do.
66954.
I think we have yours.
Great.
So people that come in that I don't know as well, that I ask for their bar numbers. Thank you. It's easier in the computer system if we have your bar number. It just populates everything a little better. All right. This is, I believe, a motion to set aside, this is a motion by the defendant to set aside the last order, I believe, of the court.
The order of October 15th.
And there's a,
Which is not the last order.
no, that's not the last order, is it?
No, the last order is the
August
contempt.
5th, August 13th, August 15th.
One of those, the
Yeah.
contempt order, Your Honor.
The order regarding the contempt hearing.
Right.
That was entered in
was-
August of this year.
We were just here.
July 23rd, we were just here,
Yeah.
yes.
Correct.
Last order. Okay, so we have a motion for summary disposition filed by the defendant. And a motion to set aside the order resolving nuisance issues and dismiss the case. And a motion for reconsideration.
Well, I don't think that's scheduled.
That's not scheduled for today.
It never would be.
No, I don't, those do not typically get scheduled, Your Honor, unless it's something we should schedule, and we can take care of that this afternoon or tomorrow morning.
What's tomorrow morning?
I can just call for it.
Oh,
Wait, I'm confused. Okay, the motion for reconsideration says now comes a plaintiff by and through his attorneys. But you're
That must have been
that's just a misprint? Okay.
Yes, correct.
that's defendant's motion for reconsideration.
Correct.
You don't have any motions, Mr. Zussman, is that
I
correct?
do.
You do have a motion.
I have a motion to tax costs, and I have a motion to select the
Oh, the
excavator. Pardon me?
excavator motion,
Yeah.
yes. All right.
I have the excavator motion and the cost motion.
All right, sorry. Well, let's proceed with defendant's motions first. In regards to your motion to set aside the order resolving the nuisance issue,
Your Honor, I'll simply respond or reply to the defendant's response. Essentially, they're claiming that because Mr. Robbins failed to respond to the answer and failed to mention at all during the 2 or 3 hearings with regard to the order that all of the allegations of the complaint have been and should be deemed admitted, and therefore there was no error that was committed by the court in issuing the order. Your Honor, I do have an affidavit from Bradley R. Johnson, the attorney of Mr. Robbins, prior to my appearance in this case, in which he states that there was an agreement with plaintiff's counsel with regard to not filing a response to the complaint, as they were going to attempt to resolve the matter without incurring greater legal fees for the parties. Now, the fact that there was a resolution entered does not negate the issue of the order itself having problems. As I mentioned in my motion and in my brief, the order calls for trespassing on the southerly neighbor's property to complete the swale. I believe is the term that's used in the order. And that cannot happen. Mr. Robbins cannot trespass on someone else's property to complete and comply with the order. Also, the landowner of the property in which Mr. Robbins is currently residing has prohibited any further construction or digging or anything else on his property, and therefore the order was defective in that it did not include the landowner. It did not contemplate the trespass upon the southerly neighbor's property, and even though it was resolved, there was an agreement placed on the record, Mr. Robbins never admitted, never placed anything on the record or testified to the fact that he was in control of the property, that he operated or created the nuisance, or that he was in fact the owner of the property. And at this point, Your Honor, there's no way for Mr. Robbins to legally comply with the order, and there are so many deficiencies with the order at this point that it must be set aside.
Well, the problem is that if there's deficiencies in the order, your client certainly contributed to them. He dug a ditch, right?
Yes.
He dug a ditch.
Yes.
In response to the concerns raised by the plaintiff. He dug a ditch.
Correct.
So he certainly acted as if he had the ability to control that property. So any deficiencies in the order, as it's described, are not, he does not come in here with clean hands. He acted in this court on numerous occasions as if he had control of that property. And for him to, at this point, suddenly say, whoops, I don't own the property, so sad, just let me out of it. That, to me, is a fraud on the court. I honestly feel that I have been lied to. Maybe not overtly, but certainly in a very intentional, subtle fashion. And it does not make the court very happy.
And I would understand that, Your Honor. If I may point out, the issue here we have, Your Honor, is that Mr. Robbins...
Mr. Robbins has created a mess, is what he has done for this court. Because now we have this mess, where we have property that he claims he can't do anything with now after he created the mess. And now he's saying he's prohibited from the landowner from doing anything to the property that he created the mess on.
If I may respond, Your Honor, the landowner, Brian Ortman, is currently in this court today and has been at every single hearing since this case began back last year.
Even more fraudulent if he didn't tell me that at the time. Even more fraudulent when we're making orders and talking about what we can do, where your client said in testimony, he testified. Did he not?
Your Honor, I have reviewed
He did testify.
I reviewed the settlement agreement placed on the record back on September 24th. There was no mention at all. And, Your Honor, as I understand it from Mr. Johnson, Mr. Zesson and Mr. Brunger both knew that Mr. Robbins was not the property owner.
No one told the court that.
I understand, Your Honor. This was...
Well, I don't understand. I don't understand that at all. I'm completely baffled by the fact that these parties can come in here and do all of this work on a case, waste the court's time, in essence. It's beyond my comprehension what has happened here. It's beyond my comprehension.
The issue, Your Honor, is that the parties were attempting, in good faith, to resolve the matter.
What good faith?
Your Honor, the agreement was placed on the record on September 24th. On October 2nd or 3rd, Mr. Robbins contacted Mr. Berksford, the engineer, to resolve the matter. We've already had this discussion, this testimony.
We had a hearing. We had an evidentiary hearing, didn't we?
Yes.
Yes.
before the order was even entered by the court, Mr. Robbins believed that he had complied with what had been requested of him. Yes, there was the issue of whether it was a ditch or whether it was a swale. Now, understand that per his belief at least, it had been resolved. He dug the ditch with full knowledge and consent of Mr. Ortman, the property owner, in an attempt to lessen the legal fees because this was a simple dispute over where the water was going to flow, and they dug the ditch. Yes, there was no intent to defraud the court. Both parties knew what was going on the entire time. That the court was not informed, yes, it was an error, but here we are.
I'm not going to accept any inference that I participated in this fraud on the court. That's absolutely wrong. He is the person who has been in control of that property. He has managed that property. He has dug on that property. He dug a pond on that property. He put the spoils on the property line, creating a dam. He has been there every step of the way, and never has he ever said, I don't own the property, I don't control the property, I don't manage the property, I don't have the ability to effectuate any change. I'm not going to be, because I attempted to settle the case, be inferred to participate in the fraud that they've committed upon the court now by coming and saying, hey, we don't really have any ability to effectuate the change that's been ordered. When he sits in front of the court and stipulates that I will participate in the process to correct the problem that I've created. He did it on 2 different occasions. He entered a consent order, and on the third, he said, he came in and testified under oath and said, I'm making the changes. I talked to Mr. Bexford. I did everything I was supposed to do, and I shouldn't have to do anything more. I'm not in contempt of the court's order. Exercising complete control over the property all the while in doing the things that he did. Never did Mr. Ortman come and say, you can't do it. These are all things that Mr. Robbins came to court and said, I will do, I can do, I did do.
He did it all with the consent and knowledge of the landowner, Your Honor. And again, we would be glad to request an evidentiary hearing. Bring Mr. Brad Johnson in here, who has indicated to me that this was an understanding that all the parties had in an effort to resolve this matter as quickly and as efficiently as possible, to simply move forward with that agreement as it was stated on September 24th.
We don't need an evidentiary hearing, Your Honor. We have a motion filed under 2.612C1, A, C, and E. You can look at what they've alleged in the court rule, and it doesn't even come close to being enough evidence to support a request for relief at this point. In A, they claim that there's a mistake or an error because we, the plaintiff, named Mr. Robbins as the plaintiff. I'm sorry, as the defendant in the case, as the person creating the nuisance, either intentionally or negligently. That's what the complaint was for. We didn't make an error. He is the person who we watched dig the pond, put the spoils there, create the nuisance. He is the person against whom we filed a lawsuit, and the person against whom the law recognizes as a person responsible to abate a nuisance that they've created. And I've cited the case in my brief. You know, if the defendant created the nuisance, he is subject to the jurisdiction of this court to abate the nuisance. That case is cited as Gelman Sciences, Inc. versus Dow Chemical Company.
Yeah, so I would state that Mr. Robbins was not the one that was operating any of the equipment. He's not the one that dug the pond. He is not the one that did any of the construction of this pond or placed any of the material or the spoils, as it's being referred to, on the property. It was another company that was hired by Mr. Ortman at that time. Again, we do have some chaos, some mess, but I'm not quite sure what the plaintiffs would like to do at this point.
Cite the court rule that entitles you to relief. That's what I want. That's what you need to do.
There is failure state of claim at this point. There was
no. This is the motion to set aside the order.
We're going to have one thing at a time here. We're not talking over each other. We've done enough of that. Thank you. Continue, Mr. Alvarez, and Mr. Zesman. I'll give you an opportunity to respond.
Thank you.
Again, Your Honor, the order has deficiencies with regard to even if there was no issue with regard to who controlled the property or who has rights to the property, there is a deficiency in the order and the recommendation by the engineer that requires whomever to trespass upon a third party. That third party is necessary in this case in order to resolve that issue. If there's going to be any kind of construction on a third party's property, that person or that landowner is required to be included and given their opportunity to be heard.
So why haven't you added those parties to this case?
Your Honor, that's not our purview. That is the plaintiffs. They're the ones that are bringing this case.
Well, I'm going to hold your client responsible for things, and I guess if he wants to fight with the landowners and the third party, he's going to have that fight. If they're not going to be a part of it, then that's his choice.
Okay. That is the court's prerogative.
I would address the issue of trespass, Your Honor, by saying that if you read the Latitude Engineering Survey of August 9th, 2012, which is attached as an exhibit to the October 15th, 2012 order, it says that you construct a swale to restore the natural flow of water. The natural flow of water has always gone in a southwesterly direction towards these blueberry fields that have a ditch that runs adjacent to the southern property line of Mr. Robbins' property. You don't have to go on the property to restore the natural flow. The swale simply separates all the spoils that were put there, creates a place where water can collect, and it evacuates by gravity in a southwesterly direction. So there is no reason why we need to trespass or encumber or go upon anybody else's property by foot, with a machine, with a pipe, with anything.
I thought this issue was raised at the time of the evidentiary hearing regarding the contempt issue, wasn't it not?
Yes, he testified to all these things.
I thought so. And did anyone order a transcript?
No.
No, Your Honor. And Your Honor, that ditch is not connected to Mr. Robbins' property. It is on the property of his southernmost neighbor, but is not connected. And so there would necessarily be, and I believe the order does say, connected to the ditch at the southernmost part of the property. So it contemplates that the ditch is connected to Mr. Robbins' property, but it's not.
It's not a ditch. It's a swale.
I'm talking about the ditch on the southern property owner's property, which is what the swale is supposed to be connected to, Your Honor.
Well, in regards to this motion, the court is not going to set aside the order. I don't believe that the defendant has raised an issue under MCR 2.612 sub C. That comports with the court rules. I think that in this particular case, the court's recollection, and I don't have my notes from that hearing, so it's a recollection, and is that throughout this case, the defendant has in fact held himself out as someone who can control this property. I never realized until this motion came in that there was this third party owner, not even a party, third person, who actually owned the property. I had no idea. For the court to get to this point in time and not have a concept that there's someone else who actually owns this piece of dirt is interesting, I think, to say the least. And I was not advised of it. I don't believe I was ever told that. If it comes up in a transcript, I'll eat my words, but I do not believe that ever occurred. The court always understood that there was a attempt to resolve this case between the plaintiff and the defendant. The plaintiff and defendant were acting as adjacent property owners, and certainly, if he didn't say the word owner, he certainly was clear from the court's understanding that the defendant lived on that property, that he had made changes to that property, and as a part of those changes, they came to an agreement to try and resolve issues that occurred to plaintiff's property as a result of what the defendant did. never did the court have an understanding that someone else had control of that property to resolve this issue. So, in regards to MCR 2.612 sub C, the defendant is citing C1A, subsection C, subsection 1A, C, and F for relief. And as noted by plaintiff's counsel, the case of Gelman Sciences versus Dow Chemical, I believe is the case that was cited. That even if there was a mistake, court can still conclude that the defendant had control over the property at the time the plaintiff suffered injury from the nuisance, and thus no mistake has occurred to justify relieving the defendant from the court's order. That was a decision from Gelman Sciences. I haven't seen a showing that the defendant that the plaintiffs concealed the material fact from the court. I don't have any information from that. We had an evidentiary hearing on this case. I do not believe that it's appropriate to grant defense motion. Defense motion is denied. There's also a motion for summary disposition. This motion and the court, based on the pleadings before the court, I don't believe it's timely filed, number one. Summary disposition motion should have been filed in September of 2012. There was never any other motions filed in regards to that. This motion is subsequent to a show cause hearing, and it seems it's very untimely pursuant to the court's scheduling order, and the court will not hear it. There is a motion to turn an excavator. I believe the court determined at the show cause hearing that the parties could not agree on an excavator. The court would have to choose between excavators, and that was the court's order, is my recollection from the last hearing. Mr. Zessen has submitted an excavator's name from RP Septic Systems and Excavating.
That's correct, Your Honor, and I've attached a copy of his license to my filing with the court.
And I believe you also submitted an excavator's name.
Correct, Your Honor. With reference to the plaintiff's recent submission of an excavator, we would need to strike that submission, Your Honor, in that it is also untimely. The court required that the submission of excavator be done by August 13th. Mr. Zessen, that very day of the contempt hearing, submitted an estimate and from an excavator, licensed excavator, I believe at that time, and we submitted ours, defendants submitted ours, within the time frame allowed by the court. So any new excavator estimate should not be considered by the court.
Well, I have an estimate. I don't remember this one. It's Generation 3 Excavating. Is that something?
That's the one I gave you on July 23rd.
Okay.
He's licensed, and he's...
$3,555.
Yeah.
And then
He had difficulty in his schedule, and I think once he got wind of the fact that it involved a lawsuit, a potential police surveil or oversight while they do the excavating, that he got cold feet, so he went and got a secondary. I mean, he still meets the qualifications of being licensed and being an excavator and having.
He's not willing to do it.
He's just came to Scott and said, you know what, I heard what's going on out there. I don't really want to have a police escort with my equipment.
I'm looking. I thought you submitted one for some reason.
I gave you a different one on Friday, and that was the RP.
Right, but I mean Mr. Alvarez.
Yes, there was one from
Hassink.
Hassink Excavating.
I'm not finding it for some reason. I know I saw it. It was a significantly different price.
I believe it was $600 was the estimate, Your Honor.
I don't understand why there's such a huge difference between the two.
One's licensed and one's not.
They are both licensed for Mr. Hassink Excavating.
I've got the Department of Licensing and Regulatory Affairs out information. Mr. Hassink is not licensed in any form, fashion, or design.
Do you have a license, just some proof of license?
Pardon me?
I'm sorry, I just found it. $600 from Hassink Excavating. Do you have a license for?
Your Honor, we do not have it with us. We can certainly submit that to the court for its consideration.
Well, I suppose I didn't say this at the hearing. I probably should have, but I did intend for it to be a licensed excavator. I didn't.
It's in the order.
Yes.
It's in the order.
Is it?
It is in the order.
Okay, I don't remember saying it one way or the other, to be honest. So,
Right.
but there isn't a license attached to your submission. Maybe what I need to understand a little bit more in making a decision here is what's the difference in these cost estimates? Why is there such a huge difference?
I couldn't
We're
tell you, Your
talking
Honor.
about a $3,000 at the minimum difference, or potentially a $4,400 difference.
Well, the $3,500 from RP really includes a removal of the spoils, and it's the same estimate that Gen 3 provided. Gen 3 was going to leave the materials on site and they would be re-excavated. The extra $1,500 from RP that's added at the bottom is if the spoils were to be removed off-site, were to be taken to some other location. So there was a hauling fee for about 2,000 square yards of dirt that had to be removed, and so that is the reason why there's a $3,500 plus a $1,500. But essentially, if the spoils are to stay on the property, which they can be, there's no reason to have them removed. But if they are to be, then Gen 3 and RP are exactly the same quote.
Oh, all right, thank you.
And both are licensed.
Well, I'll give you 14 days to submit a license, and then the court will make a decision. I don't know if it'll be either of your parties' submissions, but the court will make a decision.
Okay.
And in regards to attorney fees,
At the end of the contempt hearing, Your Honor, I made a request,
you did.
and you said I don't have the right information to make a decision at that point, inferring that I could submit a motion, and I did within the time period permitted by the court rule. I've attached a tax bill of costs, an attorney affidavit, itemized time entries for the work that I did, and everything that's required by MCR 2.625 and MCL 600.2591. I believe the court has the ability in this case to grant as a penalty for the contempt hearings a reimbursement of attorney fees, which I've outlined. But more than that, Your Honor, in the order of October 15th, 2012, there is a reservation of the issue of damages, which was supposed to be sent to the district court for a resolution. The district court passed on that, indicating that they didn't feel like they were in a position to be able to do that since they hadn't participated in the rest of the hearing. So we've submitted our statement of about $7,925 for the attorney fees that commenced back in May of 2012 all the way through the filing of responsive pleadings to the court for this particular motion. And so they are $7,925 at this point. They are continuing to accrue as now Mr. Ortman has now filed a lawsuit claiming trespass as well, to which we have to respond, and obviously the ongoing cost of seeing the enforcement of the order. But I think the court got a pretty good flavor of the attitude of Mr. Robbins in his testimony, and the furtherance of this fraud upon the court that continues to transpire, and the attempt. You've now got a motion to reconsideration under 2.119 that you have to look at, claiming that your ruling on the contempt motion was wrong, and the same thing over and over and over again. You've got the wrong person. It's not me. I can't do it. I don't need. The owner is prohibiting me from doing it. I don't think it needs to be a swale. I dug a ditch. All these things that have come up, and this has just been what has gone on since last May. He's never accepted responsibility for the fact that he created a nuisance, that he engaged in the process of negotiating this so that he could abate the nuisance in some way, and then when he agrees with the court on October 15th to engage in a process which would abate the nuisance, he completely does something completely different and is left with then an order to show cause that we had to file in May of 2013, a court hearing that of a couple hours of evidence that we heard on July 23rd, and even after you did all that, they still bring a motion for summary disposition not timely filed, and a motion to set aside an order from October 15th, 2012, which the court ruled on enforceability on July 23rd, and they insisted on having another hearing yet today. So, I mean, this is a process that needs to end, and it's not going to end until the court imposes some sanctions that the court is permitted to do now that they have found Mr. Robbins in contempt. And so I've attached all my fees. I asked for reimbursement of those as well as a tax bill of costs, and I appreciate the court's comment.
Your Honor, number one, I believe the court's order of July 23rd contemplated the fees and costs associated with having to enforce the order of October 15th, not entire fees from the beginning of the case. That issue, according to the order from October 15th, was to be resolved by the district court. If it is not been or is not able to be resolved by the district court, then that matter is not properly before the court at this time and should be ruled upon some other motion that needs to be filed by the plaintiffs if they so desire. Because that issue was left not for this court, but for the 57th District Court. Additionally, Your Honor, just with regard to the time entries, I mean, Your Honor, essentially the plaintiffs are requesting that Mr. Robbins pay for consultation regarding divorce of the parties. That certainly has nothing to do with this case or this matter in any way. Neither does the lawsuit brought by Mr. Ortman for a separate matter, not having to do with this particular dispute. Again, we also have the issue, as I raised in my response, that the hourly rates vary, and we have no explanation for why. From $166.65 per hour to $194.43. That's it.
I can explain why they vary. This case got so far out of hand that I didn't have in good conscience an ability to charge him the $200 an hour, which I would normally charge at an hourly rate, because the things that were going on could hardly be justified in light of what was going on the property. So it was my decision to make a discount under our retainer agreement. I have the ability to do that, and I did it as a favor to Mr. and Mrs. Brunger. With regard to the Ortman complaint, there is an answer and a motion to consolidate because under the court rule, the allegations are exactly the same by Mr. Ortman against Mr. Brunger regarding the same piece of property, the same facts, the same legal claims. Mr. Ortman is claiming as a property owner of the property that Mr. Robbins occupies that somehow Mr. Brunger has created a nuisance on the property. So included in my response and my counter complaint against Mr. Ortman, I will have a motion to consolidate. It does arise out of substantially the same facts and a common question of law that involves the same piece of property. So for Mr. Alvarez to say it has nothing to do with this case, it has everything to do with this case, and I suspect Mr. Ortman wouldn't be here and wouldn't have filed a complaint had it not been for the fact that Mr. Brunger first filed a complaint against Mr. Robbins seeking relief from the nuisance that Mr. Robbins created on apparently Mr. Ortman's property. So, I mean, this is something that's going to continue to go on and on and on, all this, shell game and new parties and all this kind of stuff, and it's just very, very frustrating to know that he created a nuisance, he admitted he created a nuisance, was provided an opportunity to resolve the nuisance, and has done nothing but create more time and expense in this court.
Well, I think in reviewing the attorney fees, the court I believe it's appropriate in this case for the court to award attorney fees based on the amount of work was put into this case to enforce the order. And the calculations that the court has in regards to that would be to represent 21.02 hours of work expended in an attempt to enforce the order until the present time. I think that Mr. Zussin has properly stated under the Woods case the necessary . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . issues that the court is to review in regards to awarding of attorney fees. And the court is to determine a reasonable hourly rate, a reasonable number of hours in order to achieve what the amount should be. Mr. Zesson obviously has been an attorney in practice for as long as I've been around, so I don't know, a long time. Around 30 years at least. He's often in our court and in other courts. He practices, I know, actively in Ottawa County and Allegan County. He has significant experience and is respected by his colleagues. I'm aware of that. This case, he was successful in this case. This is a case that presents a variety of difficulties that he has obviously put significant effort and utilized expert witnesses as necessary for the court to understand the case. He's had a significant relationship with his client in regards to this issue and other issues. I think that in this case, in looking at what is an average hourly rate for this area, which the court, through the assistance of its law clerk, looked at the State Bars of Michigan's 2010 Economics of Law Practice Attorney Income and Billing Rate Summary Report, which breakdown of rates in Allegan County has a median rate of $200 an hour and a mean rate of $231 an hour. The court is going to order that the defendant pay a sum of $4,729.50, representing $225 per hour for 21.02 hours of work expended in enforcing the order. I don't believe it should go back to the beginning of the case either. The defendant also asked for costs regarding filing of two motion fees and engineering fees. At this time, the court is going to allow the motion that had to be filed for costs that were filed for the order to show cause and the motion fees, $40 and $150, so that's $190. The engineering fees are part of the show cause hearing, as I recall. Well, I'm not sure. The engineering fees were done pursuant to the stipulated order.
He also testified on the 23rd, though, Your Honor.
He did testify on the 23rd, and I don't know what is that what your fee was for, just the testimony?
And preparation for that testimony, right?
That didn't include any of the actual review of the property to determine what needed to be done, and
No, Your Honor.
it's just for his testimony and
right.
his...
Yep.
All right, the court will order